All right.
Yeah, they don't give you time.
Good afternoon and welcome to the Assembly Committee on Commerce and Labor. Secretary, please take roll.
Assemblywoman Backus.
Present.
Assemblyman Carter.
Present.
Assemblywoman Duran.
Here.
Assemblywoman Hardy.
Here.
Assemblywoman Howdigi.
Here.
Assemblywoman Kasama. Assemblywoman Monroe Moreno. Assemblyman O'Neill. Assemblywoman Torres. Assemblyman Yeager. Assemblyman Urick. Chair Marzola.
And I am here. Please mark Mr. Speaker absent excused and mark members present once they arrive. Welcome everyone here in Carson City, anyone in Las Vegas, and everyone listening over the phone lines. Today we will hear 4 bills: Senate Bill 40, Senate Bill 57, Senate Bill 355, and Senate Bill 386. Before we get started, I would like to make a few housekeeping announcements. Please turn off or silent all your electronic devices. If you wish to testify, please sign in by the door. If you have a business card, please provide one to the secretary. If you have handouts for the committee, please provide 20 copies to the committee secretary prior to your testimony. For those testifying online, please be sure to mute your microphone. When testifying, please turn on your microphone and clearly state and spell your name for the record. I expect courtesy and respect in all our interactions. And with that, we will go to our first agenda item. I will now open the hearing on Senate Bill 40, which revises provisions relating to manufactured housing. Mr. Is it Acroth?
Acroth, yes.
You may begin when you're ready, and I am very happy I said it right.
Thank you, Chair Marzola, members of the committee. For the record, Steve Acroth, Administrator of the Nevada Housing Division. Proud to introduce and present SB 40, which is what we're referring to as the Manufactured Housing Modernization Bill. Ultimately, it will streamline our operations and expand our lot rent subsidy eligibility requirements. The division, and specifically Mr. Tim Whitwright, who is my co-presenter down in Las Vegas, has worked a number of years in the creation of this bill, engaging many of our manufactured housing ecosystem partners to ensure that we are capturing their needs. So I will now turn it over to Mr. Whitwright in Las Vegas to present the bill.
Thank you, Mr. Acroth, and good afternoon to our Committee Chair, Assemblywoman Marzola, and members of the committee. Again, my name is Tim Whitwright, Deputy Administrator, Housing Division out of the Las Vegas office. As Mr. Acroth mentioned, I am pleased to outline the key points and benefits of Senate Bill 40. However, before going through that, just wanted to briefly mention that 17 of the 26 amendments involve primarily just one amendment, and that is to establish a consistent reference to a certificate of title. Current statutes refers to a title as both a certificate of ownership and certificate of title. Now, today's presentation will deal with the remaining sections involving various and more substantial amendments. Again, as noted in our overview, the Housing Division has worked over the past, it's been 4 years, actually maybe 4 years plus, to develop a culture of partnership in our role in regulating manufactured housing for the state of Nevada. We have listened to our partners and customers and have collectively developed the framework for what is now represented in SB 40. Our goals include enhancing communication and coordination with our partners and customers, increasing efficiency and effectiveness, creating and supporting customer-friendly processes, reducing consumer costs, and removing barriers. I want to say that again, removing barriers to the use of existing and future technology to help us achieve these desired improvements. So, improve service. SB 40 will improve and support service to the public by allowing electronic distribution, submittal, and processing of applications, the supporting documents, as well as the delivery of those products. Now, this will positively impact licensing, titling, permits and inspections, plans review, reporting, and other related manufactured housing functions. Just the use of email, for example, for sending, accepting, and processing will enhance communication and coordination and provide greater access to our services. Customers will be able to complete applications, make payments online, and submit via email. Applications and documents can also be sent to multiple parties to ensure that there is coordination. Now, the use of this current technology will eliminate or reduce travel, fees, mailing and postage, and eliminate incidents of lost mail and, of course, the documents within that mail while saving time. So in supporting partnerships, SB 40 will positively impact our industry professionals, including dealers, manufacturers, lenders, title companies, lien holders, and our government partners, such as our assessors, building and planning departments. These amendments allow for electronic submittal of forms and reports, such as the dealer report of sale, as one example, and expanded methods for providing endorsements by our county assessors. SB 40 will also impact our lot rent subsidy customers, as contained in Section 18 within the amendments. This particular amendment regarding lot rent subsidy will benefit these applicants by creating a more equitable and expanded income eligibility criteria. The determination of eligibility, income eligibility, as it pertains to the income should be based on actual local housing conditions and costs rather than just a single income level for the entire country. Now, I've talked about customer service, and I say it is. It's about customer service. Let's talk about that for a moment. That is to say, SB 40 is a step on the path toward next-level customer service. It's about improving the experience for everyone through communication, coordination, efficiency, accuracy, convenience, and cost reductions to our consumers. Now, technology plays a big role in our customer service vision. So this is why technology is key. As noted in our next slide, to allow for an online titling services, we must remove existing barriers that prevent us from using technology. As an example, Section 26 repeals current language that requires the use of pen ink on paper in order to complete a titling process. SB 40 removes this language and instead supports electronic transactions, including county assessor endorsements, which is just one example of many that improves customer service. So benefits of going digital. What I'd like to do is walk you through, there are several, by the way, benefits, but I want to walk you through just, for example, the county endorsement process as it currently exists, and then draw a comparison to what the process will look like upon approval of SB 40. So today, every title transfer requires the endorsement of the county assessor in which the home is located. The endorsement provides proof that taxes are paid and allows the assessor to update the responsible taxpayer records. Currently, the applicant must travel to the assessor office, present their paperwork for pen ink signature. If taxes are owed, the applicant must pay before the paperwork will be signed. Once the paperwork is endorsed or signed, the applicant must either travel to the Housing Division office to present the completed, signed, and notarized application and pay the $60 Housing Division title transfer fee, or mail the documents with a check to the Division office. Once received by the Division, the paperwork is scanned and the hard copy is sent to our Carson City office where it is assigned for processing. Now, SB 40 would allow that same applicant to use technology to accomplish the same tasks with minimal travel and cost. The application can be filled out online, then emailed to the assessor for endorsement. If taxes are owed, the counties have online payment options. Once endorsed, the assessor will email it back to the applicant. The applicant will, in this one portion of the process, must print the page and bring it to a notary for signature. The applicant can access the Division online payment portal to pay the Housing Division's title transfer fee. That completed, signed, notarized, and endorsed paperwork, along with the receipt, can all be scanned and emailed to the Housing Division, and it can be easily tracked. In many cases, a delivery and read receipt can also be included. The title transfer application submittal process is accomplished with just one travel trip, and that was the notary, saving time and money, and avoiding any incidents of lost mail, and of course, any of the original documents that would have been contained therein. So benefits to customers. SB 40 will reduce or eliminate the hardships to applicants, including those from out of state or even outside the country, and to our rural communities, and to our applicants with low income and or physical disabilities. So real world examples, those include applicants who have to take time off from work, and in many cases resulting in a loss of income, traveling literally hundreds of miles in our rural communities, and I do mean that literally. There are applicants who must travel more than 100 miles each way to get either to our office or to an assessor's office. And then there are persons who physically are incapable of traveling altogether. Applicants who depend upon public transportation and the limited service schedules, as well as the fee for that transportation, fees to pay express mail service, or experience the loss of mailed items and all of the original documents contained, or loss of interest rate locks, or even a failure to close escrow on sales of manufactured homes. Now, I mentioned earlier lot rent subsidy, so I want to talk about that just a little bit more as well. The Housing Division offers affordable housing assistance to persons with low income that helps reduce the cost burden of space rent within manufactured home parks. Applicants are currently required to income qualify using only the federal poverty guidelines. Now, those guidelines apply to all 48 contiguous states. SB 40 creates a more equitable income criteria that recognizes regional housing costs and availability differences specific to Nevada in addition to that federal poverty guideline. Now, this will expand eligibility while still focusing on our most underserved populations. Real-world example here is that federal poverty guidelines will oftentimes favor the larger households, whereas the home income limits, which are specific in this case to the state of Nevada and regions therein, would favor the smaller households. So again, this does expand the eligibility for our lot rent subsidy applicants. Now, technology in action. Been talking about technology. Well, finally, we can offer you a glimpse of what is possible in our endeavor to provide more efficient customer service. The division is developing instructional videos to be accessible online 24/7 wherever internet is available. Videos could be played and paused as the viewer completes the form section by section with very detailed instructions. Now, in fact, those who want to catch a glimpse of an actual next level exceptional customer service can contact our division, and we're happy to share with you a sample of the title transfer instruction video. I believe on the slide you have my direct line, phone line, as well as email, and we'd be happy to provide that to anyone who's interested. Well, thank you for listening to the presentation, and again, I am certainly happy to answer any questions of the committee.
Thank you so much for the presentation. I believe committee members do have a couple of questions. We will start with Vice Chair Howdigi.
Thank you, Madam Chair. Just a quick question in regards to Section 18, which is the subsidies for the monthly rent, the space rent. I know that some of the changes we're making, it's going to allow the administrator to change the monthly income qualifications, and you're going to do it through regulations. And so I was just hoping you could walk us through what kind of criteria you're going to use. I'm not too worried because we're going to see the regulations come before the Ledge Commission, so I know we'll get to participate there as well. But I was hoping you could kind of walk us through the criteria that you're going to use when establishing the monthly household income. Thank you.
Thank you, Assemblywoman Howdigi, for the question. Steve Acroth for the record. Effectively, what we will be using will be HUD home guidelines. And so those are published annually, and as director or administrator, deputy administrator, just trying to give you two promotions there, Tim, Whitwright discussed. They are actually more significant, particularly in those 1- and 2-person households, so they're a little bit higher. So we're going to be able to accompany more folks that's in there to be eligible for the subsidy. Currently, I think there are 93 households on the lot rent subsidy program. It has decreased over time. And so we will be looking at expanding this to allow for those home incomes. To give you an idea, the federal poverty level for an individual right now sits at, or from 2022, 13,590. So you would have to be below that to receive funding in 2022. In Las Vegas, that in 2022 would bump up to 17,200. So we hope to get a few more people qualified to take advantage of this program.
Thank you, and I appreciate you guys doing that, Administrator. And I just had a follow-up with that because I know there's also the assets component for someone to qualify for that subsidy. And I know that in these parks, like sometimes the space rent can be really, really high, sometimes as much as what somebody would pay for an apartment. And so have you guys thought about possibly increasing that too? Because I know one of the qualifications on there is that these families or this household not have assets valued more than $12,000. And I mean, that could be a paid off car. And so if they have a paid off car, then that would disqualify them from being able to access these subsidies. And so I was wondering if, maybe not now, or if now or in the future there had been any consideration for raising that as well, the assets as well as the income level.
Steve Acroft, Administrator of the Nevada Housing Division. Certainly that would be some of the items that we could take care of via regulation. And so one step at a time to get to this point. Is that in statute? Okay. One step at a time. So I think probably the first step here is to increase the eligibility, and because we don't want to stress the program so much that we cannot provide the maximum benefit to these folks. And then I would have to say that in 2025, we would come back and change some of that in statute.
Assemblywoman Kusama.
Thank you, Chair, and I think this is a great bill to expand eligibility so that we can help more people. I think that's a wonderful thing. I did notice under Section 18E, it does say which assets are excluded, and it currently says one motor vehicle, so, and a few other things. So whether we address more in the future, that might be good too. The one question I had when I'm looking at the on the slides, the software program, just curious, is that a software program that has already been used in other states or jurisdictions that has been shown to work well? Because it sounds like that's going to be the whole new program that's adopted.
Steve Acroft, thank you for the question. I will defer to Mr. Whitwright because he's in that every single bingle day.
Very good. Thank you very much. Again, Tim Whitwright, the Deputy Administrator, Las Vegas office, for the record. The software program currently used for manufactured housing operations actually does exist in other states. However, with respect particularly to titling, I believe we are the only user in the United States that I'm aware of. There are other licensing uses, and I believe it's also used by some other agencies here in, or at least one other agency here in Nevada. Also, just to make sure that I'm answering the question, the bill looks to, as I had mentioned earlier, remove any barriers to existing and future technologies. So our interest is that if other technologies that may not exist now come into being, or other software, for example, as well, that we make sure we don't have any barriers to using those, again, seeking efficiency and customer service.
Wonderful. Thank you.
Committee members, any additional question? Assemblyman Yurek.
Thank you, Chair. My question comes out of Section 19, and it looks like we've made some changes here to reduce the number of sections I guess a mobile home has to have and the square feet considerably. I was just hoping that maybe you could help contextualize that change.
Apologies, Steve Acroft. I'm looking it up right now. Steve Acroft, for the record. Effectively, what we're trying to do is to ensure that we can accompany more product into this. I think you will hear testimony and support shortly to explain better exactly what that number generates. But effectively, what we're trying to do is make sure we encapture and clarify and basically match it up with existing product that's out on the market.
Thank you for that answer. Any additional questions? I don't think so, so we will move to testimony in support. Is there anyone here in Carson City wishing to testify in support to Senate Bill 40? Please state and spell your name for the record. You may begin when you're ready.
Thank you, Madam Chair. For the record, Susan Fisher, SUSAN-FISHER, with McDonald Carano speaking today on behalf of Nevada Housing Alliance, which is the coalition, statewide coalition made up of manufactured home dealers and related vendors. And first off, I would like to thank Mr. Acroft and Whitwright and also Director Reynolds for allowing us to use Section 19 to do an amendment to the bill. We are very supportive of the bill as a whole. There are some very important streamlining and changes that they've made that will make it easier for dealers. They've eliminated some multiple steps, and also in making it easier to submit records electronically. That's really important for our dealers as well. Helps us hold down costs, which we can hopefully pass on to our purchasers. But what we did with Section 19 of the bill, this is creating parity, because as it stood, when it said more than one section, and it had a limitation saying in Section 19 sub 2A5 that the home must consist of 1,200 square feet of living area unless the governing body prohibits that. We want to make sure that the local governmental entities still have some control over it, but by limiting the minimum size to 1,200 square feet, you could not put a manufactured home on a property as a smaller one as an accessory dwelling, because a lot of places will limit the size of the accessory dwelling to under 1,200 square feet. And therefore, we didn't have parity with site-built or modular homes. And modular homes and manufactured homes, you can't tell the difference between the two. They look exactly the same. And they're built almost exactly the same. And actually, they're built the same as site-built homes as well. It's just that we get to bring ours in and set it on there. So this just creates parity, and it removes the discrimination against manufactured homes. Thank you. I'd be happy to answer any questions.
I don't think we have any. Thank you, Ms. Fisher. You may begin when you're ready.
Good afternoon, Madam Chair and members of the committee. For the record, Mindy Elliott with Flynn Judici Government Affairs, here on behalf of the Nevada Housing Coalition, and on behalf of Christine Hess, the Executive Director for the Nevada Housing Coalition, which is a statewide nonprofit to promote and advance affordable housing solution. We are here to express our support for Senate Bill 40 as amended that will streamline processes for Nevada's lead housing agency, the Nevada Housing Division, and also expand housing affordability and stability for more extremely low-income Nevadans. As importantly, the increased efficiency in the process will also be felt by the Nevadans interested in applying for this program, saving them time and money in travel. According to the National Low-Income Housing Coalition, 81% of our extremely low-income Nevadan renter households pay more than half of their income on their housing costs. That represents nearly 80,000 households in Nevada. While the changes proposed by Senate Bill 40 cannot solve this crisis, every Nevadan and family that can move from housing insecurity to a place of housing stability makes a difference to that individual or the family, and ultimately our state's future prosperity. We very much appreciate your hearing the bill today, and we appreciate your support. Thank you.
Thank you for your testimony. Is there anyone else here in Carson City wishing to testify in support? I don't see anyone. Is there anyone in Las Vegas wishing to testify in support to Senate Bill 40? Broadcast, is there anyone on the line?
Thank you, Chair. The public line is working, and there are no callers at this time.
Thank you. We will move to testimony in opposition. Is there anyone here in Carson City wishing to testify in opposition to Senate Bill 40? I don't see anyone. Is there anyone in Las Vegas wishing to testify in opposition? Broadcast, is there anyone on the line?
Chair, there are no callers in opposition at this time.
We will move to neutral testimony. Is there anyone here in Carson City wishing to testify in neutral? I don't see anyone. Is there anyone in Las Vegas? Broadcast, is there anyone on the phone lines wishing to testify in neutral to Senate Bill 40?
Chair, there are no callers in neutral at this time.
Thank you. Would you like to give any final remarks?
Steve Acroth, Administrator of the Nevada Housing Division. Just want to thank you for your time and consideration of the bill. Thank you.
Thank you, and thank you for being here today. I will now close the hearing on Senate Bill 40. I am going to take the bills out of order just a little bit. I will now open the hearing on Senate Bill 355, which revises provisions relating to financial services. Senator Lang and Senator Hemmen, you may begin when you're ready.
Thank you so much. Good afternoon, Chair Marzola and committee members. I'm Roberta Lang, representing Senate District 7 in Clark County, and I'm here with Senator Scott Hammond, representing District 18 in Clark County. And thank you for the opportunity to present Senate Bill 355 in its first reprint, which is a bill that addresses the licensure and regulation of financial institutions in our state. As we know, Nevada relies heavily on financial institutions to keep its economy running. The institutions provide vital services to businesses and individuals alike, including loans, savings accounts, and investment opportunities. However, the licensing process for these institutions is sometimes seen as overly burdensome and time-consuming, which can discourage potential new entrants into the market. This is particularly concerning given the changing nature of the financial sector and the many new fintech firms and online lenders entering this space. If Nevada wants to remain competitive in the changing landscape, we must ensure that our licensing process is streamlined and efficient. Another area that requires attention is the regulation of protections for senior citizens and vulnerable persons in Nevada. While regulations are already in place to protect these consumers and ensure that financial institutions are operating in a safe and sound manner, these regulations must be updated to reflect the changing nature of the industry. With the rise of digital technology, many lenders are now able to provide loans to borrowers without ever meeting them in person. While this can be a convenient option for borrowers, it also raises concerns for fraud and identity theft. As such, there's a need for clear regulations to ensure that remote lending is conducted in a safe and secure manner. By streamlining the licensing process, updating regulations, ensuring that safe and secure remote lending, Nevada can continue to attract new entrants into the financial sector and support the growth of the economy. And with that, I'll turn it over to Senator Hammond. He'll go through the sections of the bill.
Boa tarde. How are you doing this afternoon? Scott Hammond, Senator from District 18 for the record. I'm going to go over the sections of the bill starting in Section 1. Section 1 removes the requirement for applicants to provide a physical address for the main office of the proposed depository institution during the licensing process. Instead, the Commission of Financial Institutions can require the applicant to provide a general location and submit the physical address before commencing business operations. This change acknowledges the growing trend of digital and remote banking services and streamlines the application process. If you turn to Section 3, Section 3 extends existing provisions governing actions that a financial institution may take to report known or suspected exploitation of older or vulnerable persons to include specific procedures that a financial institution may take to temporarily delay a requested disbursement from or a transaction involving an account of an older or vulnerable person. Section 16.5 provides that a person is not required to accept a power of attorney if another person reports or knows about suspected exploitation or delays transactions due to such suspicion. In Section 5, the legislation permits employees of licensed lending businesses to work remotely, provided they adhere to certain requirements. This measure adapts to the changing landscape of work, allowing businesses to adapt and innovate their operation. Then, of course, in Sections 6 through 8, they outline additional requirements and restrictions to ensure data security and maintain operational integrity for remote employees. Section 17 of the bill exempts licensed lending businesses from existing data breach notification requirements, while Section 9 establishes specific notification provisions tailored to the financial industry. In the event of a data breach, the licensee must notify affected residents after discovery or notification of a breach of security of the data. Section 10 mandates that any licensee required to notify more than 500 residents due to a single breach must also notify the Attorney General. One other point of business we wanted to bring is that we've talked several times. We've made a couple of amendments. There's another proposed amendment coming from Clark County. We're going to probably have Ashley Kennedy come up during testimony afterwards, and she'll present that amendment to you all. And we consider it a friendly amendment to the process. And that's all I have right now.
And I would say before we open it up for questions, Madam Chair, is we have worked over the interim. We've had several meetings with stakeholders for the past 2 years, pulling together the information to be able to do this bill, and senior financial literacy and making sure seniors' money was protected in institutions was of paramount importance to us. And so you'll see a big focus on that in the bill. And with that, we're happy to answer questions.
Thank you, and thank you for bringing this presentation forward. I do have a question, but I will give my committee members a chance first. Committee members, any questions? I don't see any, so I'll get to mine. Section 3, subsection 5B, page 5, I believe, line 25, where it states to where the financial institution would be immune from civil, criminal, and administrative liability. On that sub B, delaying, which I completely understand, a request of disbursement, so they would be immune. But then it says, or not delaying.
And Senator Hammer, for the record, that is the amendment that is going to be presented to you from Clark County. They are going to address that, and we like I said, we consider that a friendly amendment.
So are we deleting that part? Do you know?
I'd rather let Ashley explain to you. I think what she wants to do is she wants to amend it a little bit so that we can. She has it right here. Amend Section 5B of Section 3 to provide immunity if a financial institution does delay the disbursement of assets upon receiving a report or known or suspected exploitation. She wants to talk a little bit about that because she wants to make sure that we're still taking care of those folks in case there is a delay. So,
Okay.
yeah. I guess, well, I'm hesitating because I really wanted her to explain it when she comes up. And I think
She's actually
here.
right behind you.
Do you want to come up here now?
Can you come up?
If you don't mind, Madam Chair.
Not at all.
Okay.
Please state your name for the record.
Thank you, Ashley Kennedy, representing Clark County, and thank you, senators, for kind of the late hour amendment is not on Nellis, but we have it here. So what I am testifying on behalf of Clark County's public guardian, who is tasked with protecting the social well-being and economic welfare of individuals who are legally incapable of managing their affairs. So what our amendment seeks to do is to amend subsection 5B of Section 3, which is, Chair, what you were mentioning. And what we want to do is strike "or not delaying." What this would do is just ensure that an institution is immune from liability for delaying the disbursement of assets if there is known or suspected exploitation of a senior. We support that immunity. We want to make sure that if somebody potentially is being exploited, or we know that they are being exploited, that we are protecting their assets from being dispersed.
Perfect, thank you, and that completely answers my question, and I appreciate that amendment. Committee members, any additional questions? I don't see any, so we will move to support testimony to Senate Bill 355. Is there anyone here in Carson City wishing to testify in support? Please state and spell your name for the record, and you may begin when you're ready.
Chair Marzola, members of the committee, Connor Kane, CONNORCAIN, on behalf of the Nevada Bankers Association, we are in support of Senate Bill 355. As you've heard, this bill covers many different topics. I'd like to focus my testimony on one of the topics that we spent a considerable amount of time discussing this interim: how to enhance the tools that financial institutions have to protect Nevada's seniors against financial exploitation. As many of us know, our seniors are vulnerable targets for fraudsters. They're trusting of others, often live independently from family members, can be mentally or physically vulnerable, and like me, can be technologically challenged. As a result, adults 65 and older lost more of their savings to fraudsters than any other age group. In fact, 1 out of every 5 adults over 65 have been victimized, with women nearly twice as likely as men to be victims. Under existing law, when a financial institution, and more specifically its officers or employees, knows or expects exploitation of an older or vulnerable person, it must report that exploitation to Aging and Disability Services and local law enforcement. This bill does not change that duty. What it does do is add an additional tool that these folks can use to protect their customers by providing them with a safe harbor to temporarily delay a suspicious disbursement or transaction. The Nevada Bankers Association appreciates the time and effort the bill sponsors have invested in Senate Bill 355, not only this session, but as you heard throughout the interim, and encourages your support. Thank you.
Good afternoon, Chair Marzola and members of the committee. For the record, Dylan Keith, DYLANKEITH with the Vegas Chamber. We would like to thank the sponsors as well as the stakeholders for their work on this bill. We are specifically in favor of this bill for the protections that Mr. Kane was going over, and we kindly ask for your support. Thank you for your time.
Good afternoon, Chair Marzola and committee members. Brian Reeder speaking on behalf of the Nevada Credit Union League. Similar testimony, NCOL would like to encourage your support and thank the bill sponsors, particularly for the collaborative efforts to protect seniors from fraud and abuse. Thanks.
Is there anyone else here in Carson City wishing to testify in support? Is there anyone in Las Vegas wishing to testify in support to Senate Bill 355? I don't see anyone walking up. Broadcast, is there anyone on the line wishing to testify in support?
Chair, there are no callers in support at this time.
Thank you. We will move to opposition testimony. Is there anyone here in Carson City wishing to testify in opposition? Is there anyone in Las Vegas wishing to testify in opposition to Senate Bill 355? Don't see anyone. Broadcast, is there anyone on the line?
Chair, there are no callers in opposition at this time.
Thank you. Lastly, we will go to neutral testimony. Is there anyone here in Carson City wishing to testify in neutral? I don't see anyone. Is there anyone in Las Vegas wishing to testify in a neutral position? Please state and spell your name for the record. You may begin when you're ready.
Hi, Sandy O'Loughlin. That's OLAUGHLIN, Commissioner of Financial Institutions Division. I'm here in neutral and here to answer any questions. I did work with Senator Lang and Senator Hammond on the bill.
No one has any questions. Thank you for your testimony today. Is there anyone else in Las Vegas wishing to testify in neutral? Broadcast, is there anyone on the line wishing to testify in neutral to Senate Bill 355?
Chair, there are no callers in neutral at this time.
Thank you. Senators, would you like to give some closing remarks? Okay. Thank you for being here today. We will now close the hearing on Senate Bill 355. I will now open the hearing on Senate Bill 57, which revises provisions to insurance. Commissioner Scott Kipper, you may begin when you're ready.
Good afternoon, Chair Marzola, Vice Chair Howley, members of the committee. For the record, my name is Scott Kipper, K-I-P-P-E-R. I'm the Insurance Commissioner here at the state of Nevada. It is my honor to be here today representing the Division of Insurance and to present Senate Bill 57. I am joined today by Justin Worthington, the division's legislative liaison. Very briefly, a little bit of background. The insurance industry has a significantly large footprint in the state of Nevada and has grown from $11 billion in written premiums in 2012 to now over $22 billion in 2021 and continues to grow. The premium tax from that level of premium is the fourth largest contributor to the state's general fund, with $1.2 billion of revenue being projected by the Economic Forum for this biennium. The Division of Insurance is not a general fund agency. Rather, it is an enterprise-funded agency that assesses a fee to those entities whom the division regulates for our budget. The Division of Insurance regulates approximately 1,700 insurers that are admitted to do business in our state, along with an additional 150 captive insurers who are domiciled in Nevada. The number of licensed producers or insurance agents in Nevada has increased by over 100,000 over a 2-year period, growing from approximately 150,000 licensed producers in 2020 to now over 250,000 producers. The insurance industry employs over 40,000 Nevadans, and those jobs generate well over $2 billion in annual wages. I will now provide you a brief review of the changes proposed in this bill. Because the bill addresses numerous chapters in Title 57, we have provided you an explanation table for Senate Bill 57, which is a summary of each of the changes in the sections of those bill, along with the corresponding rationale for each change. Section 1 changes the current requirement for health carriers submitting a copy of every provider denial letter to the commissioner to now submitting a report that summarizes those provider network denials and to make a copy of every denial letter available to the commissioner upon request. We believe this will create greater efficiencies in the marketplace, both for carriers and for the division. Section 2 has been deleted by amendment. Section 3 removes the phrase threatened act and adds the language that is related to the business of insurance in subsection 2. This section also moves the deadline to hold a hearing from 30 to 60 days to accommodate anticipated workload, and it also provides that commissioner shall issue a final order in a contested case within 45 days after the close of the hearing of that contested case. These changes are necessary to simplify important deadlines, which will ensure the division can effectively manage cases. Section 4, which the division worked closely with the Attorney General's office, makes confidential, with certain exceptions, additional records and information relating to an investigation for the prosecution of insurance fraud. Requires such records and information to remain confidential during and after the conclusion of the investigation, and places the responsibility of release on such records on prosecuting attorneys, not just the Attorney General. The new requirements are necessary because criminal investigations are sensitive, and disclosing investigative information could potentially undermine case prosecution. Section 4.2, as a matter of practicality in this modern environment, authorizes a paperless option regarding electronic delivery of health plans. Accordingly, covered persons of a health plan, as defined in the section, must opt out of electronic delivery of notices for notices to be delivered by the U.S. mail. But before consenting on behalf of a covered person, a plan sponsor must also confirm, by reasonable means, that the covered person routinely uses electronic communications during the normal course of employment. And importantly, the section provides exceptions for cancellation, non-renewal, and termination notices. Section 4.4, 4.6, and 4.8 add references regarding Section 4.2 and reflect necessary statutory references. Section 5 revises the terminology used to describe fees in NRS 680B.010 to match the language used in statute. The amount of such fees remains unchanged, and the section also removes duplicative fees. The change will allow regulated entities to better understand and interpret requirements for these license types. Section 7 provides that the commissioner has discretion to require a managing general agent to file and maintain a surety bond with the commissioner. The commissioner will also have discretion to require a surety bond of managing general agents because of the direct contractual relationship between an insurer and a managing general agent. Section 8 requires a third-party administrator to notify the commissioner within 30 days of changes to the administrator's members, owners, directors, or officers, along with changes to their physical location, mailing address or electronic mail address, or legal or fictitious name. Section 9 revises NRS 683A.025 to provide clarity that any person who administers a program of pharmacy benefits for an employer, insurer, internal service fund, or trust must be licensed as a third-party administrator. Many pharmacy benefit managers, or PBMs, have already obtained a Nevada administrator's license, so this clarification will be helpful to properly enforce relevant statutes for all PBMs. Section 10 simply makes a conforming change to reference Section 8 of this bill. Section 10.5 makes a conforming change to reference the exception found in NRS 683.086, which corresponds with Section 13 of this bill. Sections 11 and 12 revise requirements for an out-of-state applicant for an administrator's certificate of registration to include in their application the authorization document issued by their home state and requiring the applicant to comply with all applicable provisions of Title 57 and related regulations to renew their authorization. These revisions will enable the division to verify out-of-state licenses and ensure compliance with Nevada law. Section 13 clarifies the subcontracting of administrator duties is not permitted between a third-party administrator and an unlicensed third-party administrator. The proposed changes generally will ensure that TPAs meet their obligations and that if an issue arises, the division can adequately address the issue. Section 14 adds language allowing the commissioner to require an applicant for a license as managing general agent to submit a copy of any contract between the applicant and each insurer that the applicant will represent as a managing general agent, in addition to meeting the bond requirements set forth or contained in Section 7. Section 15, 19, and 36 authorize the commissioner to renew a temporary license as a producer of insurance, independent adjuster, and exchange enrollment facilitator for an additional period of 180 days under circumstances like concluding certain estate matters or completing tours of duty in the military. Sections 16 through 18, 20, and 40 through 42 revise provisions concerning the licensure of insurance consultants, business entities, adjusters, insurance agents, and firms or corporations to clarify, standardize the circumstances in which an agent of an insurer is required to designate a natural person to represent the agency or to be responsible for the agency's compliance with the laws and regulations governing insurance. The term appointment is also removed from the statutes in favor of the term sponsorships because the division views these terms as unique and distinct, which will also allow regulated entities to better understand and interpret the requirements of each license type. Section 21 was deleted by amendment. Section 22 prohibits individual and small group health plan benefit insurers who have removed a prescription drug from a formulary from adding that prescription drug back into the formulary in a higher cost tier in the same plan year in which it was removed, except at the times and under the circumstances provided for under existing law. Current statutory language provides a loophole that enables a carrier to remove a drug from this formulary and then add it back. This section would then effectively close that loophole. Section 23 reduces the minimum allowed rate for determining annuity non-forfeiture benefits from 1% to 0.15% to help ensure insurer solvency and to bring Nevada's annuity non-forfeiture rules in line with the National Association of Insurance Commissioners model law updates. Section 24 allows for the sale of contingent deferred annuities in Nevada by clarifying that this type of annuity, which is designed to provide guaranteed lifetime income payments, if an investment account is exhausted during the life of the annuitant, are not subject to non-forfeiture rules because contingent deferred annuities are not designed to accumulate value. Section 25 and 27 relate to prepaid contracts for funerals and cemetery services and clarify that the requirements of NRS 683A.301 apply to an applicant for a certificate of authority. The intent behind this change is to ensure that the names of funeral and cemetery sellers are not deceptively like existing entities. Section 26 requires a person to have a good business and personal reputation to qualify for an agent's license to sell prepaid contracts for burial services on behalf of a seller. Most licensees under Title 57, including a funeral agent, are required to have good business and personal reputation, so this language standardizes the requirement for sellers of burial contracts. Section 28 defines the term replaces the definition of the term health benefit plan in NRS 689C.075 with the definition used in NRS 687B.470 to promote statutory consistency and reduce potential confusion. Section 29 clarifies that the provisions regarding confidentiality and disclosure of certain records and information that apply to traditional insurers also applies to captive insurers domiciled in Nevada. Sections 30 through 32 moves the annual filing deadline of the statement for financial conditions for various types of captive insurers from March 1 to June 30. This change will allow captive insurers to provide annual report filings using audited financial information. Section 33 through 35 makes conforming changes necessitated by the renumbering of the fees table included in Section 5. Section 37 provides that Nevada rules of civil procedure do not govern the provisions set forth in NRS 696B.250 regarding the commencement of a delinquency proceeding, petition, or order to show cause, which is necessary because each are extremely time-sensitive. Section 38 eliminates duplicative statutory language regarding the powers of the commissioner as a receiver, rehabilitator, or liquidator of an insurer. The intent is to remove potential confusion regarding language of authority and compensation of those hired in receiverships, and to ensure the NRS are consistent with Uniform Insurers Liquidation Act and Insurer Receivership Model Act. Section 39 adds language to clarify that when a receiver is to be appointed in delinquency proceedings for an insurer, certain persons that may be appointed and certain staff that may be employed in relation to delinquency proceedings serve at the pleasure of the commissioner. Section 43 and 46 establish that only a bail enforcement agent is authorized to take certain actions with respect to the apprehension and surrender of a defendant. Section 43 also removes the term dwelling in favor of the term structure. The changes are necessary because bail enforcement agents and bail agents continue to use unlicensed persons to locate and apprehend defendants. Bail enforcement agents must meet very specific qualifications to engage in locating, apprehending, and surrendering defendants who have failed to appear in court. These qualifications, which include rigorous training, distinguishes the bail enforcement agent from the bail agent. Section 44 provides that a bail agent who improperly causes the surrender of a defendant to custody is not entitled to collect any fees related to the surrender. Section 45 prohibits a bail agent, general agent, bail enforcement agent, or bail solicitor from allowing any person other than a licensed bail enforcement agent to participate in the functions of a bail enforcement agent. Section 49 removes the phrase threatened act from existing language in NRS 315.725 sub 9. The revision signifies a necessary change in conforming with Section 3. That concludes my introduction of Senate Bill 57, Madam Chair, and we look forward to answering questions of the committee members, and I appreciate your patience as we read that into the record.
Thank you for your presentation and for being very thorough. We appreciate that. We will start with Assemblywoman Torres.
Thank you, and thank you for the presentation and taking the opportunity to meet with me last week ahead of this presentation. I did have one specific question regarding, it looks like it's Section 43 of the bill, page also. page 43, as it turns out. And I noticed that we have some language in there regarding bail enforcement agents. And as I look at that, I see that we're striking the language that notes that, if an individual violates the provisions of this section is guilty of a misdemeanor, they would be guilty of a misdemeanor. So what teeth would the bail enforcement agents have to follow these provisions?
Madam Chair, members of the committee, for the record, Justin Worthington. Assemblywoman, to your question, I think that is something that I will have to look into and then get back to you as soon as possible. Thank you for your question.
Vice Chair Howdicke.
Thank you, Madam Chair, and thank you, Commissioner, for also meeting with me before the hearing today to get most of my questions answered. I just do want to take the opportunity to go over some of the questions that we had in our meeting, just to put them on the record, and I'm sure some of my colleagues might have the same too. Specifically around Section 3, where we talked about extending the hearing date from 30 days to 60 days, and then requiring that the commissioner must have a final order within 45 days. And my concerns around that area, where if someone is being charged with an allegation of improper conduct, that they would still allow, because it's an alleged charge, that they would still be allowed to practice or produce or sell insurance. My concern in that area, as I shared with you, is that someone might be out of work for more than 3 months, and people out of work need to still pay bills, and so that, again, that they would still be allowed to practice, because we are taking it from 30 days to 60 days and then giving an additional 45 days for the commissioner to come out with a final order. So I just wanted to put on the record that they would, again, still be awarded full due process and allowed to continue to perform their work while this is an ongoing process.
Madam Chair, through you to Assemblywoman Howdicke.
And you can go direct.
Thank you so much. You're quite right in your interpretation that although I'm not a lawyer, it is, you are innocent until otherwise proven guilty, that an agent or anybody who would be subject to such hearing would be able to continue to perform their functions under their license as we license them during the interim period during the hearing, and until the commissioner does provide a resolution to that case.
Committee members, any additional questions? I don't see any, so no additional questions at this time. Thank you, and thank you for your presentation. We will move to testimony in support of Senate Bill 57. Is there anyone here in Carson City wishing to testify in support?
Good afternoon, Madam Chair, members of the committee. Liz McMiniman, Retail Association in Nevada, representing the chain drugstores and other retailers in Nevada. And I'm come to this table in support of the Insurance Commissioner's legislation, SB 57, specifically Section 9 and Section 22, dealing with prescription benefit manipulators. Nevada is woefully behind in regulating and doing anything with these entities that are being held accountable in other states. And I look forward to them being held accountable and possibly bringing down prescription drugs for your constituents and for the patients in Nevada, because they are the players that are creating some of the problems that we see today. So I thank the Insurance Commissioner for this. This is a tiny step. Let's see what we can do to Nevada to help them rein in these entities. Thank you very much.
Thank you, Madam Chair. Michael Hillerby on behalf of the American Council of Life Insurers here today to support the bill, in particular the sections on annuities that the Commissioner outlined. The Model Acts and the hard work of the National Association of Insurance Commissioners are important. They make sure that companies that serve customers in a variety of states have some consistent rules. but even more importantly, make sure that you retain your sovereignty over state laws and the commissioner maintains their powers over their regulated entities. Again, happy to be here to support the work the division does on this bill. Thank you.
Thank you. Is there anyone else here in Carson City wishing to testify in support to Senate Bill 57? I don't see anyone. Is there anyone in Las Vegas wishing to testify in support of Senate Bill 57? Broadcast, is there anyone on the line?
Thank you, Chair. There are no callers in support at this time.
Thank you. We will move to testimony in opposition to Senate Bill 57. Is there anyone here in Carson City? You may begin when you're ready.
Madam Chair, members of the committee, my name is Jim Wadhams with the law firm of Black & Wadhams here on behalf of Black Diamond Insurance Company. And I apologize for the lateness of this. I'm actually in support of this bill, but we do have an amendment which technically makes me in opposition. It is a housekeeping item that allows non-residents to apply to be bail agents, not bail enforcement agents, bail agents. They have to be licensed in their own state, and the language is very similar to what the commissioner, actually this commissioner himself, adopted in the 2011 session for non-resident adjusters. This is a housekeeping. It clarifies the reciprocity with other states, and I would appreciate the committee's consideration of this, and happy to continue to work with the commissioner.
Thank you. Is there anyone else here in Carson City wishing to testify in opposition? Is there anyone in Las Vegas wishing to testify in opposition to Senate Bill 57? I don't see anyone. Broadcast, is there anyone on the line?
Chair, there are no callers in opposition at this time.
Thank you. We will move to neutral testimony. Is there anyone here in Carson City wishing to testify in neutral to Senate Bill 57? I don't see anyone walking up. Is there anyone in Las Vegas wishing to testify in neutral? Broadcast, is there anyone on the line?
Chair, there are no callers in neutral at this time.
Thank you. Would you like to give any closing remarks?
Again, Madam Chair, for the record, Scott Kipper, and we just wish to thank the committee for their indulgence today, and if there are any questions, we look forward to answering them at any time. Thank you.
Thank you for your presentation today. I will now close the hearing on Senate Bill 57. I will now open the hearing on Senate Bill 386, which revises provisions relating to barbering. Senator Spearman, you may begin when you're ready.
Good afternoon, Chair Mazzola and committee members. For the record, I am State Senator Pat Spearman, representing Senate District 1 in Clark County. I was told this morning that there was another committee that was the hardest working, but since I see some of the same people, I imagine this committee is hardest working too. So last year, I had someone to come to me and tell me about a glitch in terms of licensing for barbers, and wanted to get a bill that would clarify that. Unfortunately, what we did in the bill that you have before you, some of the language is still confusing, and so in an effort to make sure that everyone understands, there are two tests to be taken. The first one is when you graduate. And when you graduate and you pass that test, then it's my understanding that you become an apprentice. And after 18 months, then you take a test to become a registered barber. And so what you see when it says apprentice, we need to strike that. And so I'd like to go down south to Mr. Marcus Allen, if that's okay with you.
Absolutely.
Mm-hmm.
Yes, Madam Chair and members of the committee, Marcus Allen, M-A-R-C-U-S, last name Allen, A-L-L-E-N. We have with us the barber board, or more so explain the terminology that we would need to use for this, and I would connect back in later.
Good afternoon, Madam Chair, committee members. Antoinette Maestas, A-N-T-I-N-E-T-T-E, last name M-A-E-S-T-A-S. I am here representing the Nevada State Barbers Health and Sanitation Board. We had heard the cries of our schools and of our licensees that, and there was probably some unfair practice here with this law, so we wanted to get it changed. I understand test anxiety. So if you go to school for 1,500 hours, you graduate, you take your first exam as an apprentice barber. If you failed it, the way the law was written, you had to go back to school for 250 hours. So what we've done with the help of Senator Spearman is they would actually get 4 times to take the exam within a 6-month period before they would have to go back to school. The only amendment I would like to see done on this is in Section 1, subsection 2, it talks about a cosmetologist. That is a crossover. That is somebody that's already licensed as a cosmetologist. They go to barber school for 400 hours. They take their exam as a registered barber. By definition, when you see the word barber, that's registered barber. Apprentice is apprentice barber. A crossover is, they test as a registered barber. So we would like to see the same wording that is in subsection 3 for the apprentice barber to be in the crossover, that they could take it the first time and then 3 times again within a 6-month period. Subsection 1, when they talk again about barber, that is a registered barber. After you go to school, you take your exam, you pass it, you go to work in a barber shop for 18 months. You work with a registered barber. After that, you come back and take your registered exam. If you listen to the people on the streets, they call it masters, but it's technically registered barber. So they never have to go back to school for that. They just continue working in a shop for 3 months and take it again. So we would like to show support of this with those amendments made, and I'm here to answer any questions that you may have. Mr. Allen might talk on some of the reasons why the 6-month was in there versus the year.
Marcus Allen, M-A-R-C-U-S, last name Allen, A-L-L-E-N. I'm the owner and operator and also Nevada instructor for Masterpiece Barber School. We did run into a problem when we became a school in the state of Nevada 8 years ago with some of the students actually getting test anxiety, taking a test and failing the test and had to do a refresher course. Refresher course takes up to 250 hours and it's also $3,000 at this present time. I'm speaking on the behalf of not only my school but the other schools here in the state of Nevada that we reached out and would like to have this changed and for this, and also that with the 6 months period, we would need that for financial aid. All the barber schools together in Nevada is reaching out to get financial aid for more students will be able to go to a school than ones who couldn't afford it. Within the 6-month period, we have to have a quota that we have to meet within that 6-month period to report back to the Department of Ed. And also it would be more so best for within the 6 months that we have the students get to work faster than waiting for a whole year to actually get to work. Thank you.
Does that conclude your presentation, Senator?
Yes, ma'am, it does.
Thank you. Assemblywoman Kasama.
Thank you for the bill. I'm actually surprised that you didn't have the opportunity to retake tests. I know with the real estate license, they're allowed to go and retake the test, so we're allowing that in industry, and this certainly, I support being able to do it in this industry as well, so thanks for bringing the bill.
Thank you, Assemblywoman. For the record, Senator Pat Spearman, District 1. And so that was one of the things that came up when they asked me would I carry the bill to change the law, because other professional licensings, there was an opportunity to take a test, but the way the statute's written right now, it didn't allow for that.
Committee members, any additional questions? I don't see any questions, but Senator, just so I can visualize it correctly, so I go to school, I take a test to graduate, and then I start my apprenticeship. I maybe do not pass that test, and instead of retaking it, I would have to go back to school at this point?
Without this bill,
Correct.
And I will defer to Mr. Allen and Ms. Maestas if I got that wrong. So what the bill would do, it would allow for the retaking of the exam within a certain time period. And so when they graduate and take the exam, they are simply a graduated applicant. Once, if they pass that, then they move into the apprenticeship portion. If they don't, they have 6 months to take it 3 more times.
And I guess I'm just in shock that someone would have to go back to school in order to retake the test. So thank you for bringing this bill forward. I don't think there are any other spaces that this happens, right? Whether accounting, legal, like Assemblywoman Kasama said, real estate. So I appreciate this. Assemblywoman Torres.
Thank you. And, thank you for the presentation. It's great to see you again. I know it's been a long time since our last committee meeting together. But, based off of the conversation, I was kind of thinking the same thing. Like, it doesn't make sense that we have it in practice that, like, you have to go back to school. And I see that there's still language that requires it. Is there any reason why we would still, require individuals get like the 250 hours if it's more than 6 months after that initial examination? If you could walk through maybe some of the reasoning on that.
Sure, Senator Spearman, Senator District 1 for the record. And so I'm going to defer to Mr. Allen.
Yes, we was saying at first that we actually had, Marcus Allen, Masterpiece Barber School in Las Vegas. First, we had it where it was a law stated that if you you take the test one time and you actually fail the test, and you have to come back and do a refresher course after taking it one time. We opened the window because in case you have test anxiety or you was just nervous or you wasn't comfortable that day or didn't study enough, that you will not have to do that. We think it's very important if you failed at least after 4 times, it's very important that you come back to school because it's something you might have to miss, and it's very important that you get it back at school because us as barbers, we deal with razors and we're dealing with clients. So we don't want someone to be failing a test and then go out into the field and actually put a razor on someone that can cut them or hurt them real bad. And then we understand that, with a razor in someone's neck or anything like that would cause some significant damage or injury to our city. So most definitely we would like for them to come back and do a refresher course after the 4 times. I hope I answered the question.
Thank you.
Committee members, any additional questions? I don't see any. So, Senator, we will move to testimony in support of Senate Bill 386. Is there anyone here in Carson City wishing to testify in support? I don't see anyone. Is there anyone there in Vegas with you guys?
No, there's not.
Oh, thank you. Broadcast, is there anyone on the line wishing to testify in support to Senate Bill 386?
Chair, there are no callers in support at this time.
Thank you. We will move to testimony in opposition to Senate Bill 386. Is there anyone here in Carson City? I don't see anyone. Still don't see anyone in Las Vegas. Is there anyone on the line, Broadcast?
Chair, there are no callers in opposition at this time.
Thank you. Is there anyone wishing to testify in neutral to Senate Bill 386? I don't see anyone here. I don't see anyone in Las Vegas. Broadcast, is there anyone on the line?
Chair, there are no callers in neutral at this time.
Thank you. Senator, would you like to give any final remarks? I will now close the hearing on Senate Bill 386. I will now open up for public comment. Please address your remarks to issues that fall within the jurisdiction of this committee. Public comment is limited to 2 minutes per person. Is there anyone here in Carson City wishing to give public comment? I don't see anyone. I don't see anyone in Las Vegas unless you two are wanting to give public comment.
No, we're done. Thank you.
Thank you. Broadcast, is there anyone on the line wishing to give public comment?
Chair, the public line is open and working, and there are no callers at this time.
Thank you so much. This concludes our meeting for today. Our next meeting will be Friday, May 5th at 1:30. This meeting's adjourned.